Welcome once again to Lehto's Law. Here's Steve Lehto.
Roger sent me a note and said, Steve, recent Supreme Court activity has me wondering about something. He goes, so here's the case that got me thinking about this. And he said, quote, I'm not really asking about this case in particular. I simply want to know what this means, referring to what the Supreme Court did. So here's the thing. We're going to talk about a very hot button topic today in relation to something else. I'm not going to get into the hot button topic itself simply because, number one, ain't no one going to change their minds on it. Number two, it would take me about 12 hours in a video to go off and discuss all the nuances of the issues. And number three, this is what I do here. I don't do political stuff on this channel. I try not to, at least not this political. So the story's from Politico, from Bianca Quillanton, and she says, the headline, Supreme Court passes on transgender bathroom challenge. The Supreme Court passes on it. And the question is, what does it mean when the Supreme Court simply refuses to hear something? Does that have a legal effect with stare decisis? And that's the notion that you look at precedent when you need to decide how a law is to be interpreted. And so, is it precedent when the Supreme Court passes on something? And the answer to that, of course, is yes and no. The Supreme Court's decision is seen as a major victory for transgender student rights, especially as a number of conservative states passed laws to challenge them. And the Supreme Court, on Monday, passed on a long, winding legal battle over transgender students' rights to use bathrooms that match their gender identity. And the Fourth Circuit Court of Appeals sided with one of the parties twice, ruling that the policy is unconstitutional under the 14th Amendment's Equal Protection Clause. And I'm not going to get, like I said, heavily into the policies or anything like that, but the point is that there was somebody involved in the lawsuit, and on two different occasions, the Fourth Circuit Court of Appeals agreed with that individual. The court also said that this issue touched on Title IX, which is an educational law that prohibits sex-based discrimination. Now, for several years, the case has bounced around the courts through a turbulent political tug-of-war over the interpretation of Title IX. And so this is the second time this term that the Supreme Court has sidelined a lawsuit aimed at barring transgender students from bathrooms and locker rooms based on their gender identity. So here's the issue. I'm not going to get into that. Get into this. A case gets into the courts. Someone files a lawsuit. They file the lawsuit in a federal district court. We're talking about federal issues here, not state. And although the parallel is probably there in most states as well. But so somebody says, hey, my constitutional rights are being violated. They file a lawsuit in the district court, the federal district court. The federal district court rules one way or another. That ruling now affects that case. However, one party doesn't like the results. So they file an appeal and take it up to the Court of Appeal. And there's going to be several different circuits. Like the Sixth Circuit is the circuit that Michigan is in. The story I'm talking about right there is in the Fourth Circuit. And the Fourth Circuit covers a bunch of states. The Sixth Circuit covers a bunch of states. And each circuit will cover a bunch of states. Right? Okay. So when they take it up to the Circuit Court of Appeal, and that appellate court makes a ruling, that ruling affects that particular case, but also it becomes the law in that circuit. So if I am in Michigan and I am thinking about filing a lawsuit and I see a law that I think applies to me, I can go, oh, I wonder if that law applies to me. And I can go then search the opinions of the Supreme Court, if they've ever touched it. They haven't. Let's assume that. So then I go and look at the opinions from my circuit. Has the Sixth Circuit ever weighed in on this issue? And I might find cases that say, yes, they have. I might find cases where they got close to it. I might not find any cases at all. I might then look to other circuits to see, well, has any other circuit ruled on this? And this is where the problem arises. You might find that the Sixth Circuit has never ruled on this case, but the Fifth Circuit has. Now, what's happened in the Fifth Circuit is not binding on the Sixth Circuit, but it might be used as an argument. So if I go in front of the courts in the Sixth Circuit and say, hey, look, I want this ruling reversed because I don't like the result. You guys have never ruled on it, or gals. And however, the Fifth Circuit has, and they've ruled in our favor. And so I think you should adopt their reasoning. But their reasoning is not binding on this circuit. it can be instructive, it can be educational, it can be something you point to, but your opponent might say, by the way, however, look at the Second Circuit. They've ruled the other way. And so you can get a split in circuits. But as you go up the ladder, if you want to look at it that way, the rulings from above you apply to you. The rulings in parallel circuits, like I said, they might be instructive, but they're not binding. And so what can often happen is you can have a situation where some law is actually interpreted differently in different circuits. They refer to that as a split in the circuits. So you're sitting there and you're trying to determine if you have a case or not. So then you take it up the Court of Appeals because you lost at the district court, and you try to get them to adopt your line of thinking based on other circuits and so on. And let's suppose that a ruling then comes down from the Court of Appeals on your case, and one side doesn't like it. So they file an appeal, and they ask the Supreme Court to hear the case. The Supreme Court does not have to hear a case like that. They can choose to hear it or not, as they so wish. And they get about 7,000 requests a year from litigants saying, we want you to review our case. 7,000 cases a year. 7,000 cases a year. Out of the 7,000, they accept between 100 and 150. That's straight from their website. They accept between 100 and 150 of the 7,000 requests they get a year. If they decide to hear the case, they grant certiorari. I won't even get into that, but it's a long Latin word. Or we often just say they granted cert. And if they decide not to hear it, they decline to hear it, it will say cert denied. Cert denied. So you bring a case, you get all the way up there, and you apply to the Supreme Court, and you say, guys, gals, I want you to hear our case. And they agree to hear it. And you become one of the cases that the Supreme Court agrees to hear, one of the 100 or 150 each year. However, there are cases that they do not agree to hear, about 6,000 and change a year. And the question is there anything binding precedentially about their refusal to hear a case? And the answer is yes and no. And I know it sounds like a squirrely answer, but it's actually true, and I'll explain this to you. So quite often, legal scholars will interpret the Supreme Court refusing to hear a case as them endorsing the lower court's opinion. So going back to my example, I'm in Michigan. I file a case in the Eastern District of Michigan. I don't like the results. I've appealed to the Sixth Circuit. The Sixth Circuit rules a certain way. Somebody applies to the Supreme Court for cert. The Supreme Court denies it. A lot of people will say, Steve, that means this case stands and the Supreme Court endorses that thought process. Well, the first half of that, absolutely, it does stand because they didn't reverse it. But do they endorse that thought process, the rationale from the opinion of that court? And the answer is hard to say, because there have been examples before where people have applied to the Supreme Court, sought cert, had it been denied, so everyone assumes, oh, that denial means they agree with this rationale. And then somebody comes along with a case that appears to be similar, and the Supreme Court accepts it. They grant the cert, and then they rule and they reverse it. And so people say, wait a second. They denied the cert before and they granted it here to reverse it. Why didn't they do that over here? Well, I've mentioned before, the Supreme Court doesn't always give us broad strokes when they're answering narrow questions. Quite often they answer a narrow question and leave it. And they don't have to explain themselves. So they might accept the case and not explain why they're accepting this case versus the other case they didn't accept. However, there's no question that if you are doing legal research and you're writing a brief and you're going to go into court and argue a case, a judge may ask you, do you have any case law on this that supports your position? And the higher level case law you can get that applies to where you are, the better. So if you're in the Eastern District of Michigan and you've got a Sixth Circuit Court of Appeals case that you can point to as precedent, that's great. If you've got a Supreme Court case, that's even better. So if you find a case that appears to support your position, that was taken to the Supreme Court, but they denied the cert on it, you can cite that case. And you'll actually cite it. Johnson versus Smith, blah, 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 U.S., blah, blah, blah. And then you put the year, and then you write cert denied, indicating that somebody sought to have that overturned and it wasn't. You can do that. But it's almost like an interim level of support, meaning that the best case scenario would be that they accepted it and confirmed and affirmed your position. That's the ideal situation if they did that. However, in the case I'm describing to you right now, they didn't do that. So this case that went to the Fourth Circuit ruled on it, and then somebody applied to the Supreme Court, and they just declined to hear it. Now, are they absolutely endorsing the position of the Fourth Circuit? Well, they're not reversing it, and there's a distinction to be made there, I believe. But there's no question that unless the Supreme Court revisits the issue in another case, or perhaps this one if they do a third time, that you can cite that case, and it will simply say the case name, all the information, and then cert denied to indicate the Supreme Court didn't hear it, but they chose not to hear it, which had the practical effect of affirming the lower court's ruling, which would imply that they agree with it, but it's no guarantee that they did. And again, I know that those are some very, very fine and minor distinctions. People say, Steve, only lawyers can think like that. That might be true. Keep in mind, they get 7,000 requests a year. They pretty much only have time to handle 100 to 150 of them. And a vast majority, by the way, of the ones that they get asked about are, I believe, criminal matters, especially people on death row, because those are often taken to the Supreme Court, last-minute things. But I know that in Michigan, a majority of the cases that make it and get offered to the Supreme Court are criminal. And I believe they actually do accept more criminal than civil cases. But the point is that they're asked to step in 7,000 times. And I know people say, but Steve, let's see, 7,000, couldn't they do more than 100? Well, you need to see what goes into a Supreme Court case. I've discussed before how expensive it is. And I recently talked about the cheerleader case, the cheerleader who made the Snapchat picture that got her sanctioned at school. And that made it to the U.S. Supreme Court. She was one of the 100 and 150. And after I did the video, a very good friend of mine contacted me and said, Steve, I filed an amicus brief on that. Beth Norrell, how you doing? And Beth works at a law firm that was asked to represent some student organizations and file an amicus brief on that case. And what that means is there are two parties to that case. There's the cheerleader and there's the school. The cheerleader filed her lawsuit. The school answered the lawsuit. They went to court. From the court, they went to the Court of Appeals. From the Court of Appeals, they went to the Supreme Court. Supreme Court granted them cert. Once it's announced that the Supreme Court's going to hear a case, everyone's ears perk up. And there are people out there who go, wait a second, a case is going to get heard by the Supreme Court that is of great interest to me or my organization, and I want to make sure they rule on it properly. So not only did the Supreme Court get a brief from the cheerleader's side and a brief from the courts, the school side, they got amicus briefs, friend of the court briefs, from all kinds of other organizations, and it makes complete sense that student organizations out there that are looking out for students would want to weigh in on this. And I guarantee you the ACLU stepped in and may have filed their own brief, although I think they may have been helping the family in that case. But there's always going to be these organizations that look at something and go, we want to make sure the Supreme Court is well briefed on that and understands the issues clearly, and we want to make do what we can to influence that. And so they'll file briefs. And I mentioned before that the word brief is a misnomer. This is a brief I filed in a case. Excuse the stickies, but I use those when I'm arguing in front of the Court of Appeals. And this is appellant's brief on appeal in a case I filed in Michigan. And my friend sent me her amicus brief, and I think it was 45 pages or something. It was a work of art, by the way. It's wonderful. I read it. So the Supreme Court then has all this stuff to go through. And the justices have got clerks who help them go through the stuff. And they will then go through all the stuff, have oral arguments, then they'll come up with an opinion and a ruling and so on. But the simple point is they haven't got time to do that in 7,000 cases. So you can guess that the 100 to 150 that they actually get that they hear and rule on are in their minds the 100 to 150 of the most important cases before them. So if they've declined cert on a case, it very well could partially be that they don't have time to hear it because of all the other stuff going on, and they might not prioritize it enough to say, well, this one actually needs to be up here and bounce this other one out. So basically, they get a ton of cases. They can only rule on a handful of them. And so I suspect the best way to look at this is when they decline to hear it, they're inclined to say that they support it, but they didn't explicitly say it. So yes, you can use it as precedent when you're making your arguments, and your opponent's going to say, yes, they declined to hear it. They didn't come right out and say, yes, we endorse that opinion. And so it's one of those things where if they came right out, accepted the case, ruled in your favor, that's the best you can get. But if they declined to hear a case that went in your favor, that's the second best. And then, of course, if the circuit that you're in has ruled on it, that'll work as well. So, I've actually seen an attorney before argue and say, Your Honor, you've had this issue before you at a trial court level, and you ruled this way. And I've seen a judge say, show me the transcript. I'd like to see that. But that was in a different case. And so it's not going to be binding necessarily on that case, but it would be illustrative. It would help the judge see how he ruled previously. You want to keep that judge, honest, as they say. So it's an interesting question. And I'm really glad that Roger asked me. And again, I'm not going to step into the quagmire of the rest of what was going on in this particular case because, as Roger says, I'm not really asking about this case in particular, just curious what precedential effect, how important is it? If the Supreme Court declines to hear a case, is that as good as them hearing it and agreeing with you? And it's not that good, but it is good if it was going your way before they declined to hear it. So there you go. The Supreme Court passes on transgender bathroom challenge. The Supreme Court's decision is seen as a major victory for transgender student rights, especially as a number of conservative states pass laws to challenge them. But it's not as good as if they'd heard the case and said, yes, we agree with it, and here's why. So Bianca Quanton wrote it for Politico. Roger suggested it. Thank you very much. Questions or comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Don't get it right, just get it written.